Good afternoon, everybody. This is Grant Kaplan speaking, U.S. immigration attorney. Nice of you to join us. This is a live broadcast on our Facebook U.S. visas and green cards. Because it's live, it's an interactive session. We would very much like your participation. Please join us, show that you're joining us, give us some likes, give us some smiley faces. Do not give us any daggers, do not give us any guns, bombs, or anything else. Constructive, happy is what we're looking for. We will be talking today about deportation and removal from the United States, and I'm going to be giving you guys quite a lot of information about that. I'm going to wait a few minutes before we get into the topic to allow all of you to join us, and in as much as this is an interactive session, I'll be looking from time to time at my screen to see how we go, and also to be able to answer any of your questions as you go. If you can hear me, please give us a thumbs up on our channel. Let me check to see that all is good, and let me refresh my screen to make sure that everything is good over there, and let's see how we go. I'm looking now, the screen is jumping around all over the place. Yes, I can see me. I am indeed alive, so that is a good thing. I see that we've already got 2 likes. The people are starting to comment and to come in. We're going up to 10 likes now, but any comments, any things that you may want to add to question at any time, this is a live session. You're welcome to do so. Of course, not only is it a live session, but everyone will be able to access this after the live broadcast and for a long time to come. So if you are watching this after the live broadcast, please do not be concerned. You can certainly access this at any time. I'm going to also give you our contact information, both email and telephone. The email address is info@US Visas and Green Cards, and telephone number +1 561 347 8440. And because of today's topic, frequently in relation to deportation and removal type matters, things are urgent. After hours, things happen. People get arrested. People get deported. People are refused entry into the United States. And for that very reason, we have a 24-hour emergency line available. And you simply can access our cell phone numbers after hours by calling that same telephone number, +1 561 347 8440. I see we have over 20 likes already. Guys are coming in. Very good. Your participation, of course, is key to the success of our discussions, and the more of you guys that come in, give us your comments, give us your interactive sessions. Any questions that you may have, please come forward, ask us. We'll be very happy to answer. Just some information about us. We're an all-inclusive immigration law office based in Florida, United States. We have clients all over the United States and all over the world. We've been doing this for a long time. I'm an international attorney as well in the United States. I've been doing this for the last 18 years. We have 2 attorneys. We have 10 paralegals. We are very much an interactive law office. We make our clients feel as comfortable as possible. We guide you guys right through the process. We tell you like it is. Whatever your current circumstances are, we will lay out exactly what you can expect to see. We know what you're going through. Most of the staff in the office are immigrants, including myself, from all countries of the world. The guys in the office speak Portuguese, they speak Spanish. We're able to access other languages, Russian, Chinese, Hebrew, whatever it may be. We can certainly access people at any time to help us as we go. The staff here, as I say, are very compassionate, empathetic. Whatever you're going through, whatever your relatives, friends, and everyone else is going through, we can certainly help you, and the chances are we've seen and done it before. We also have access. I'm a member of the American Immigration Lawyers Association. We have access to experts should we need them, and we are able to help with all kinds of information and supporting documentation. Guys are starting to come in. I'd like to say hello to Bhagat, who is signing in. Hi Bhagat, happy to help you, happy to answer any questions that you or your family or friends might have, either during this live broadcast or after. Alright, so let's get to the topic at hand. We're talking briefly about deportation and removal. In the current environment here in the United States, Immigration, of course, is a hot topic. And with the current president's agenda, the removal and deportation aspects are very much on the forefront of the immigration agenda. Clearly, this is a deportation type mentality that there is, and the many so-called illegals in this country are subject to deportation at any time. So, who am I speaking to specifically? If you or anyone you know is out of status, in other words, if you have come in with a visa and you have overstayed your visa, you are out of status. If you have not come in with a visa and you've crossed the border, clearly you know that you're out of status. Hello, by the way, to Mr. Pinder in South Africa, who's signed in to speak. Nice to chat to you, Pinder. Any questions we can answer with pleasure. We can do so. And looking forward to any other inputs and comments that you guys have. So, back to who's in status, who's out of status. If you have overstayed, if you have come without a visa, clearly you're out of status. If you are in the United States and you've transgressed the terms of your visa, for whatever reason it might be, let's say you were a student and you no longer attend classes, clearly your student visa has expired because you do not attend classes any longer. So even though theoretically your visa might say that you're currently in status as an F1 with a D/S on your visa stamp indicating duration of status of your studies, although on the face of the document it doesn't appear that you're out of status, obviously if you do not attend classes the school will report that and you're out of status. Similarly, if you're on an employment visa or a trainee visa or anything like that, and are no longer working for that employer, you're out of status unless you have taken steps to remedy your situation. Hello Shirag, welcome. Nice to have you join us. Happy to answer any questions and comments that you guys have got. Now, if you are a permanent resident and you've committed a crime, if you have committed any other types of offenses, if you have remained out of the United States for a certain period of time as a permanent resident and are coming back into the United States, you may be denied entry, you may be given a deferred inspection, you may be placed in removal proceedings. So all of you guys, anyone that you may know that is in this position, is amenable to deportation or removal, as the common parlance currently says. So what does that mean? That means that depending upon what you've done, you could be taken into immigration custody. You could be given a notice to appear in the immigration court. You could be given some type of monitoring device and asked to report to Immigration and Customs Enforcement over here in Florida. The local office is in Miramar, which is a humbling experience to go down there, by the way. There's hundreds of people standing in the streets. And you know, it's really something to behold. And of course, immigration, one doesn't get a warm and fuzzy feeling going anywhere near any immigration office at the best of times, but particularly if you're amenable to removal and you're at the mercy of the officers, clearly that's somewhat of a humbling experience. I hope you guys are enjoying the session so far, by the way. If you are, please send us a couple of hearts, thumbs up, smileys, anything like that, so we know that you're there. If you have to report to ICE, my suggestion is you go with an attorney, you go with a basis to be able to remain in the United States. Do not do this alone, guys. People are being removed every single day by the hundreds, if not the thousands. The immigration courts are overwhelmed with deportees, and that is a particular problem. Hello, Mr. Derek Jackson. Nice to see you, Mr. Derek Jackson. Happy to chat to you, Mr. Jackson, and nice to hear from you. People are reporting into Immigration and Customs Enforcement in record numbers, not through any choice of their own, but because they've landed themselves into some kind of a difficulty. Obviously, you know if you're in status or you're out of status. You know if you've committed a crime, and that would make you amenable to deportation. You know if you've been out of the United States as a permanent resident for more than 6 months at a time, and would therefore face a potential issue when you come into the United States. As I say, immigration is typically unsympathetic. to any personal issues. They have regulations. They know exactly what they're doing. That's not to say that everyone is doomed. On the contrary, attorneys like us have a particular role to play. We will call it like it is. We will tell you exactly what your current position is, and we will, of course, advise you of any kind of relief or circumstances that may be able to help you with. Now, talking about DACA recipients, talking about people who've got TPS, those guys are here on a temporary basis. So if you are a DACA recipient, if you are a TPS recipient, yes, you are in status for the moment, and hopefully there will be some deal worked out for the DACA recipients. I know we spoke specifically on DACA a couple of weeks ago. Congress is still busy trying to wrestle the details as to how this would affect you guys. I personally am relatively optimistic that something will be worked out for you guys. There is presently no deal on the table as we sit here today, but certainly that seems to be on everyone's agenda, that they would like to help those who have DACA, and I'm confident at some point that something is going to work out for you. So Gladys, in answer to your question, yes, I believe that there will be some assistance coming. Sit tight. Let's see what happens as we go from there. Those guys with TPS, of course, from those particular countries, you typically will know which dates the termination of the TPS is going to take place. And my advice to you again is to seek legal advice. See what other remedies may be available to you. If you're from Haiti, if you're from El Salvador, any one of those countries that currently have TPS available, you may have other remedies available to you. You may be able to apply for asylum. You may be able to apply for adjustment through a qualifying U.S. relative. There may be other remedies available to you. So please seek legal advice on that. Now, what to do if you are placed in removal proceedings? Typically, this will take place in a number of ways. If, for example, you are a green card holder, you have permanent residence, and you have committed a crime, and that sentence requires you to have some kind of probation or supervisory release, typically that probation officer and Immigration and Customs Enforcement will find each other, and ICE, as they are commonly known, will typically come to the probation officer's premises when you are required to report, and either take you into custody or place you in removal proceedings. If you're coming into the country and you wish to file, for example, for asylum on the basis that you are afraid to return to your country, or you're a permanent resident that is returning and there's some kind of an issue that pertains to you, for example, you have a previous conviction, let's say for marijuana possession many years ago, or you stayed out more than 6 months ago, then there might be an issue relating to that, and the Customs and Border officials can either give you what is called the deferred inspection at Immigration and Customs Enforcement. They can then give you a notice to appear in court. They can place you in custody. They can refuse you admission. Any one of those would possibly pertain. I see Mr. Cameron is signed in. He says he's got an overstayed student visa. That is a potential problem for anybody. Students who or anyone else who's out of status in the United States, very difficult to get yourself back in status. Once you're out of status, clearly that means that you're amenable to deportation and you would need to leave. Now, from a practical point of view, if you leave within 6 months, you will not face an automatic bar by leaving the United States, and you're free to come in again by applying for another visa. Practically speaking, of course, when you go to the consulate, not so simple, because they will see that you have overstayed, or that you have some kind of other transgression, and frequently you will require a waiver to help you to come back in. And that again is where you would need to seek competent legal advice to prepare these waivers to come into the United States and to assist you to come back. Some offences are non-waivable, so if, for example, you've been convicted of murder or another aggravated felony, or you've come into the country on numerous occasions without inspection and been deported more than once, clearly that is a big problem, and typically you would face an automatic bar of at least 10 years. Of course, each case is specific, and we would need to go through those one by one. So again, all of those people who have specific inquiries, overstays, criminal convictions, anything like that, that is a potential issue that we will need to speak. If you come in, for example, without inspection, or you overstayed, or you have some kind of another issue, and you have a qualifying relative, let's say you marry a United States citizen in good faith. If you come in with a visa and you've overstayed, typically immigration will overlook your overstay once you marry the US citizen in good faith. They will typically overlook the overstay period, and you would be able to get your green card without any kind of issue unless you have other issues. Of course, not so simple to do this on your own. Again, I would seek legal advice and have an attorney prepare and file these for you. If you come in without inspection, Gladys has written in to ask this question. If you come in without inspection, in other words, you come in without a visa, and you marry a US citizen, or you have another qualifying US relative, namely a US citizen child over 21, or a US citizen parent that files for you and your priority date has been reached, it is possible to get the alien relative petition filed here in the United States, and once that petition has been approved, it is possible to file for what is known as a stateside waiver, and that is what Gladys is referring to, the I-601A waiver, which is applied for here in the United States. And once that is approved, then you could go back to the US consulate in your country to go and get the green card. If, on the other hand, you are in your own country at the US consulate and they discover that you have a criminal conviction, or they discover that you have another issue, then you need to file for what is known as an I-601 waiver, which is a hardship waiver. Now, both of these waivers that I'm referring to, the I-601 waiver and the I-601A waiver, are based on hardship to your US citizen relatives. So as far as you are concerned, you are not a US citizen at that point, and they want to know what hardship your qualifying US relative would suffer. And some of the levels that are required are sometimes extreme and exceptional hardship, sometimes regular hardship. It just depends on the kind of waivers that may be available. So certainly those are available. The difference between the stateside waiver and the other waiver, the I-601 waiver, is that the stateside waiver is approved here in the United States first. So that is a good thing. It's because by the time you get out to the US consulate, all of those issues should have been resolved, and your interview at the US consulate in your country is going to be a typical green card interview, the same as anybody else would have, as if they've never been here in the United States. So that's the difference between the two. By the way, if you're coming on a non-immigrant visa and you have some kind of an issue either in your own country, or you've committed an offense, or there's some other kind of issue, there is a non-immigrant waiver available to you, and that anybody can apply for, and we can see how we go on that one. But we frequently assist clients to prepare. Those are Section 212 waivers, incidentally, for non-immigrant visas, and for the I-601 waivers, those waivers at the consulate are taking probably between 3 and 6 months to be approved, because typically those waivers are not adjudicated at the window. When you go to the consulate, which is always a wonderful occasion to behold, those guys at the consulate are not the friendliest people. Your time at the window is very limited. So the guy that interviews you, say for your green card, for example, he's the guy that looks at your paperwork to see that you're eligible for the green card on its own. If, on the other hand, they find that you have an issue, whether it's a criminal issue, whether it's some other kind of an issue, they would need to take the waiver which has been filed and hand that back to Department of Homeland Security, who are separate people, not them, who are other guys who adjudicate those waivers. And that takes some time to adjudicate, and that is where the 3-6 month story comes. So not all good news, I'm afraid, but certainly these things are doable. We do them regularly for clients, frequently successful. Each case must be measured on its own merits, guys. It's no use coming to say, my friend did this and he got this done in 3 days, and why can you not do this? Each case is dealt with on its own merits. I can tell you that immigration is becoming much stricter. They are sticking to the regulations much more clearly. They are aggressively going out in terms of what is known as I-9 audits. They're going out to places of employment, and you may have seen some of the posts that we put on US visas and green cards. They raided 7-Elevens around the country simultaneously, and did an investigation to see if there were, illegals employed, so-called illegals unemployed. We do a lot of I-9 work with clients to make sure that their companies comply with immigration requirements, and of course we'll be happy to do that also for any employers out there who are looking for us to perform this service. We'll come into your company, we'll have a look at your documentation. If necessary, we'll interview your employees. We'll see that everyone is what is called I-9 compliant. There should be a file on everybody in the office, either the human resources person, or if it's a small business, the owner should be aware of the employees that he has, and that they are legal to work. And that is what immigration is increasingly aggressively looking out for. We've assisted restaurants in the past, we've assisted other businesses in the past, but we're happy to do that also for you guys. So in summary, immigration customs enforcement are moving aggressively nowadays. If you or anybody you know has any kind of an issue, please do not wait. Please get legal help. If someone has been arrested, call us immediately. If you have a criminal case going on at the moment, whether it be a DUI case, whether it be marijuana possession, have your criminal attorney contact an immigration attorney. We would be happy to work with the criminal attorney to make sure that any potential charges that are levied against you are not amenable to removal, and perhaps could be played down or taken down to a level which would not constitute compulsory removal from the United States. So all of these things should be dealt with before, not afterwards. It's no use coming afterwards to say, I was convicted of murder, but I really didn't do it. I should have been convicted of culpable homicide, or whatever it might be. Once that's done, very difficult, certainly from an immigration point of view, to go back and to go back to the to the criminal courts to try and have those charges changed. We need to go back to the criminal attorney. We need to speak to the criminal attorney. That's a whole matzah pudding, as they say in Yiddish. So better to have these things dealt with beforehand, and we can deal with them as we go. Similarly, if you're placed in removal proceedings, if you're arrested, before you sign any document of any kind, speak with an attorney. Don't consent to anything. Do not consent to removal. Do not consent to any charges. So I need to speak with my attorney, get legal advice, so that you can diligently deal with this and deal with any kind of questions or any kind of other allegations that immigration may have. You're entitled to be represented at every step in the immigration process, whether you're applying for asylum, at a credible fear interview, whether the immigration officer is coming to see you for the first time or wants you to sign any forms, whenever you're placed in immigration proceedings, whenever you have an immigration interview, if you have a deferred inspection at the immigration office, if you have to appear at the immigration court. Yes, it may be that the immigration court will not pay for your legal representation, but you're certainly entitled to representation. And unfortunately, in today's statistics, more than 80% of respondents in the immigration court are unrepresented. As a consequence, they are not given, in many cases, in my opinion, due process. They are not able typically to understand the process. Some of them, although they're translators at court, do not clearly understand the immigration process. Clearly, everyone should be given their due right to appear in court, to aggressively follow whatever rights you may have, whether you're entitled to a waiver, whether you're entitled to remain in the United States. Even if you aren't entitled to anything, you should at least know what your rights are, if and when you can come back, and how you can do that. And that is what we'll be able to happy to help you to do. Again, my contact numbers, 24 hours a day, +1 561 347 8440, and email address info@US Visas and Green Cards. Let me just see quickly if there's any other questions that there might be. I know that people are asking how long is the process for the 601 waivers. As I've indicated, probably at the consulate 3 to 6 months. In the United States, probably 3 months for the I-601 waiver. Sometimes it is possible to file for waivers during the process. There's fraud waivers, there's other waivers. So, please take legal advice from a professional person before you plead to anything, before you get yourself deported, before you find yourself in any difficulty. We'll be happy to help you with pleasure anywhere in the United States. and for those at any US consulate in the world. Please give us a call. Looking forward to hearing from you guys. Don't forget our Facebook page, US Visas and Green Cards. Good. Thanks very much, guys. Looking forward to chatting to you and to speaking to you soon. Thank you.